In this case, our group will explore and explain the Leaky building saga that began in 2002 and took place in Takapuna on the North Shore of Auckland. This case shows the negligence shown by Grimshaw & Co. towards the owners of Level 23 Spencer O'Brien apartment building. Within this case video, we will identify and explain the following topics of the case: the key facts relating to the case at hand, as well as a timeline of the events, the issues within the case, the results of the case study, the property management resolution, the proactive property management, and finally, further information about the case provided by a follow-up article. This case discusses the owners of 255 units within the tower who are involved in a lawsuit against the owners. The legal proceedings within this case were ruled by High Court Judge Justice Kiri Tanhana. The owners of the Spencer O'Brien apartment complex took legal action against their own lawyers, Grimshaw & Co., on the basis of breaching duty of care towards the owners of the apartment's body corporate. Grimshaw & Co. were hired for the purpose of the matters involving leaky building defects against the parties of Multiplex and North Shore Council, which later merged into the Auckland Council. Grimshaw & Co. settled this case with Multiplex and the North Shore Council with a settlement just over $20 million. However, a dispute over the settlement benefits arose. Grimshaw & Co. were found to have given negligent advice on settlement agreements. Following this, in 2011, the Unit Title Act 2010 came into force, which ultimately meant that common areas in the apartment building, such as the lobby and foyer, would be owned by the body corporate, and that the owners of the 255 units would be deprived of any litigation allocation for these areas. Despite the settlement, building repairs were delayed and did not start until years later. Grimshaw & Co. failed to identify the problem that the Unit Titles Act 2010 had on the agreement between the owners of the apartment complex and the Multiplex North Shore Council.
Timeline. The Spencer O'Brien apartment building was constructed and then later opened in 2000. Shortly after opening, building defects were identified in 2002. 5 years later, in 2007, the body corporate appoints Grimshaw & Co. and makes the claims for repair costs. However, in 2011, the Unit Title Act 2010 began to cause major implications. In 2013, a settlement was decided on by the body corp. Despite the settlement, in 2013, 5 years later, in 2018, the repairs and maintenance commenced. This shows a prolonged timeline of around 18 years to get building defects remedied.
Issues. This Leaky building saga case has a wide range of issues that were seen by each party. Beginning with Grimshaw's inadequate duty of care to its clients, it was seen by a judge's ruling in the High Court of Auckland that Grimshaw was not taking the best consideration for their clients and had breached its duty of care within the body corporate. Body corporate claimed repairs. In 2007, the body corporate was able to claim repair costs to fix the building defects from those involved in the construction. Having Grimshaw act on their behalf, they were able to agree on the settlement of $20,050,000, but that was not nearly enough to cover the cost of the repairs. There was also a distribution agreement between the parties, which covered any proceeds of the legal battle would be allocated between the owners. In 2011, the Unit Titles Act 2010 had come into force, which changed the ownership structure of key parts of the building, such as the lobby and foyer. The apartment owners claimed Grimshaw had breached its duty of care to them in failing to advise that after a law change, the agreement was invalid, resulting in all current unit owners being deprived of the benefit of the share in the settlement. This all leads to any legal duty neglected by Grimshaw & Co. Despite any settlement made in 2007, repairs did not start until early 2018, which had affected all apartment owners and tenants. The case has still continued on with hearings in July and August of 2020, with Grimshaw still attempting to claim no proceedings and denying duty of care to the body corporate. Resolution. Moving to the resolution of this case study, judges from Justice Tahana in the High Court of Auckland ruled in favour of the body corporate. The judges believed that Grimshaw was highly negligent and incompetent towards its duty of care towards the body corporate. A judge was able to find a competent lawyer who was able to identify and fix problems at hand and change things for the better.
Resulting actions. As a result, the judge's ruling in the case highlights that actions of a competent lawyer could have made significant difference in the outcome. Also, that the advice provided by the lawyers to the owners was deemed negligent. This highlights how crucial it is to have a precise and well-informed legal advice. If the fund had been utilized at the start of 2014, the estimated repair costs for the building were projected to be around $26 million. This amount would have been way lower than the non-estimated bill, which had spiraled. This shows the need to act quickly and have cohesive communication between all parties involved. The body corporate lodged claims for damages that covered different parts. This includes $128,000 for inter partes proceedings, $13,000 for mediator fees, $80,000 for fees charged by Grimshaw & Co., $40,000 of commission charged, and finally, $11.3 million of increase in remedial costs.
There are many solutions that a proactive property manager could have adopted to avoid or otherwise mitigate the problems faced in the case presented. Some examples of these solutions are early identification, regular maintenance, legal expertise, and risk assessment. Early identification is a critical aspect of effective property management, involving a proactive approach to protect the property's value and condition. Through constant monitoring, they are able to promptly detect an emerging issues, irregularities, or signs of things getting worn out. By identifying these concerns in their early stages, property managers can take swift and informed action to prevent them from escalating into larger, more complex problems. Regular maintenance is very fundamental for sustainable property management. It involves constant upkeep of the property, timely addressing certain problems, and minimizing impact of potential problems. Moreover, regular maintenance not only contributes to the longevity of the property, but also enhances the overall living experience for tenants. Having a strong foundation in legal expertise is a paramount of success for a property manager. It consists of engaged and quality lawyers, a property manager with comprehensive legal knowledge of property and all relevant acts, informed actions based on knowledge. The practice of risk assessment embodies a proactive approach to identifying and mitigation potential hazards within properties. Through open communication and timely repairs, property managers enhance safety, resilience, and property value, contributing to a secure environment. Last, following up with another article that branches from our original case study, we have found that Brosnan Construction, who are the company that have been elected to fix the damages, began repairing the 255 unit blocks in March 2017. They expected to have the work completed in July of 2022. It was also noted that disruption has to be largely minimized due to there being no evacuation of the building during the repairs. This second article linked below also covers more details concerning the documents and agreements which were created by the body corporate to make their case, which the judge ultimately dismissed as it was unenforceable and not provide for owners claimed by the body corporate. This finally all leads up towards the owners of the Byron apartment building winning the case against their own lawyers. Thank you for taking your time to engage with our case study on the Leaky building Saga in Takapuna.